Michael, and also thank you to the Financial Planners Planning Association for the opportunity to be able to present to everyone today on this interesting topic, superannuation death benefits in the wrong hands. And of course they're getting into the wrong hands more and more as more and more money gets into super and proportionately less into the legal estates. Trends are beginning to emerge in the cases. Us lawyers used to say where there's a will there's a relative, but I think it's we might have to change that in the near future and start saying where there's a binding death benefit nomination there's a relative. So today we're going to talk about receiving superannuation death benefits, who can receive them, who can oppose them, and what are binding death benefit nominations and how they can be used to give certainty. We'll look at the alternatives to binding death benefit nominations, as well as who should control self-managed super funds after death. And also we'll look at some recent cases and see how the results of those recent cases can by and large be avoided. Please feel free, listeners, to ask any questions as we go, and I'll endeavour to deal with them as they arise. So our first slide is, here we are, who can receive a superannuation death benefit. So SIS Regulation 621, of course, deals with this. Members' benefits must be cashed in as soon as possible after death. There's an ATO interpretive decision just issued, 2015/23, which talks about what cashing means. Cashing actually means paying, not journal entries. So they've got to be cashed out. And of course then the issue is, okay, so they're cashed out, who do they get cash to? And to a superannuation law dependent, of course, defined in Section 10. And they're defined as being a dependent, and they are a legal personal representative, or a dependent is defined as being a spouse, child, and those in an interdependency relationship. So we all know who a legal personal representative is, but I just want to now look at the issue of, who can receive a superannuation death benefit, and Section 10 talks about spouses, and with spouses they include legal spouses, de facto spouses of the same or different sex, and of course members of registered relationships as defined in Section 4 of the Relationships Register Act 2010. Many people may not be aware that the issue of registering non-legal marriage type relationships in New South Wales has been around, and you've been able to do that since 2010 in New South Wales, and there are most states and territories have similar legislation. Section 3 of the Relationships Register Act says that the object of the Act is to provide for the legal recognition of persons in a relationship as a couple, regardless of their sex, by registration of their relationship. So if you've registered your relationship under the Relationships Register Act in New South Wales, then you're a spouse for the purpose of Section 10 of the Superannuation Industry Supervision Act. Section 10 also defines a child to include an adopted child, a stepchild, an ex-nuptial child, a child of the person's spouse, and we mustn't forget the Family Law Act, which defines a child to include a child conceived by way of artificial insemination and surrogacy. Now, interestingly enough, in relation to stepchildren, it's often overlooked that unless there is a financial dependency, the stepchild will no longer be a superannuation law dependent after divorce or death of the parent of the child. And the only way around this is for the step-parent to actually legally adopt the child. That's a little trap for young players. In relation to financial dependency, this is of course relevant when we're talking about interdependency relationships, and which I'll get to on the next slide. But financial dependency was actually clarified as to what it means in the Malek case, where the court said that the relevant financial support is that required to maintain the person's normal standard of living. In that case, the member lived with his widowed mother, and her pension was insufficient to cover all her living expenses. The son topped up his mother's income from her pension, and from his own money, he topped up his mother's pension money so she could make ends meet, and she was held to be financially dependent for the purposes of Section 10. So you don't have to be totally financially dependent or require total financial support. A mere topping up is enough. So here's the slide on what interdependency relationships means. It's defined in Section 10A. There has to be a close personal relationship, have to be living together. One or both support the other with financial support. One or both provide the other with domestic support and personal care. Interestingly enough, if B, C or D can't happen because of physical, intellectual or psychiatric disability, then an interdependency relationship will still be taken to exist. Now, Regulation 1.04AA, and by the way, that's not a typo, the SIS Act is slowly becoming reminiscent of our 1936 and 1997 tax acts, with all the bits and pieces that get added to it and have been added to it over the years. But this is the regulation dealing with factors determining whether an interdependency relationship exists, and the courts look at, there are 11 factors overall. I've listed 7 of them. The courts look at the duration of the relationship, whether a sexual relationship exists, the degree of mutual commitment to a shared life, care and support of the children. One thing I didn't put in, but is one of the 11 factors, is the ownership, use and acquisition of property, and the reputation and public aspects of the relationship. That's relevant. It's just something that we often don't think about when considering the issue. The extent to which the relationship is one of mere convenience, and that obviously requires some probing questions if the issue arises. The last bullet point is rather curious: the existence of a statutory declaration signed by one party to the effect that an interdependency relationship exists. Well, as we all know, saying something does or doesn't exist doesn't make it so. And so, whilst there are no rulings on or court decisions on the point that I'm aware of, no doubt the courts will undoubtedly accept cross-examination on the statutory declaration to determine what the underlying facts really are if there's an issue. Now, of course, some death benefits can be taken in as a pension, but not all of them, and only the following on this slide can take a death benefit pension, and this is referred to in Regulation 6.21, Subregulation 2A. You have to be a superannuation law dependent, and if that dependent is a child, then the child of the member must be under 18 or between 18 and 25 and financially dependent, or suffering a disability as per the Disability Services Act, the 1986 Commonwealth Act. And in relation to reversionary pensions, which are becoming reasonably popular, the rules for payment of a pension must not allow for the pension to be transferred to any person who could not have originally received it under SIS Regulation 1.069B. So that's basically a regulation which endeavours to and will prevent reversionary pensions going from people who otherwise wouldn't qualify. So our second major heading: who can oppose a superannuation death benefit? These are generally people whom the deceased doesn't intend to receive any part of their superannuation death benefits. For example, the member may intend the benefit to go to their current spouse, but a former spouse may also qualify as a financial dependent. The member might intend to benefit their own children, but their current de facto may qualify as a spouse. Another example is the member may intend to benefit children from a former relationship, but not children from a current relationship, or vice versa, or intend to exclude one of their children. Now, any of these people can oppose a death benefit strategy, And so the client really needs to be to take positive steps to ensure that those persons are excluded from receiving a benefit from their SMSF or their APRA-regulated fund, and of course that's why binding death benefit nominations came into existence at a stage left. So what are binding death benefits? How do you use them to give certainty? Well, they're a written direction to the trustee. They set out how the members' benefits are to be paid. They displace the trustee's discretion as regards the allocation of death benefits of the member. So they are intended to give certainty, but of course more frequently now they don't. Section 59 and 59(1)(a. It's interesting, these cases, the section I should say, and the subsections of it relate to issues concerning the 3-year rule by which binding death benefit nominations lapsed after 3 years. Now, His Honour Freiberg, in the Donovan case in 2009 in Queensland, in an obiter comment, obiter means, in layman's terms, a throwaway line, if you like, which is not pertinent to the decision of the judge, but when he's considering issues relating to his decision, he'll make comments. They're called obiter comments. They're not binding, but they give a guide as to what the bench is thinking and the way they view certain sections. So in this throwaway obiter comment in 2009, he said, look, that section doesn't apply to self-managed super funds. And in fact, the year earlier, in the self-managed superannuation funds determination 2008/3, specifically that determination was to the effect that the SIS regulation 6.17A, 6.17A doesn't apply to to self-managed super funds. So it's clear now, as clear as it can be, I guess, that binding death benefit nominations in the SIS, in the self-managed superannuation fund context, can continue to operate unless revoked and aren't subject to the 3-year lapsing rule. Okay, so that's all good. So if 6.17A doesn't apply, then what does? Typically, trustee drafters will set out in the self-managed super fund trust deed the rules for the giving and operation of binding death benefit nominations, and many follow the provisions of 6.17A as a matter of course. For example, they say the BDBN must be in writing. Now, I've got a number of questions here. Can we turn the slides after the presentation? I understand that you can. What if the relationship were registered and then that relationship ended? Now, that new relationship is formed de facto just before death. How would the super be paid out? That's an interesting point. I think if the relationship ended, then one would have thought that if it's ended, you'd take it off the register. But we've got a legal system. This is a comment from Joy Choi, I think if I pronounced that correctly, or Joey Choi. The question is, what if the relationship were registered and then the relationship ended? We've got a system in our legal system which deals with substance over form. So the purpose of the registration is to register active relationships. If the relationship doesn't exist, then I really don't think that it's going to help anybody if the registration is still in existence, particularly where a new de facto relationship has occurred before death. So I think the superannuation would be paid out on the basis that the new de facto partner would be the person entitled rather than the old one. Another question from Kern Manders. Can you please explain registered relationships versus simply living together? In a de facto relationship, well, the situation there is you can have one or the other. You don't need both, and there are no estate planning consequences. The issues in relation to who is a spouse, it includes de facto spouses, it also includes people who have registered their relationship. So if you fit in one category or the other, you're fine. Can a lapsing binding death benefit nomination be renewed by the use of an enduring power of attorney? The answer is yes, it can be. There is a case on that which I'll get to, but the person who used it for their own benefit and for circumstances particular to the case, and it ended up failing. But the court did say that an enduring power of attorney can be used to draft a binding death benefit nomination, and I infer from the decision that, in answer to Jackie Annandale's question, it would also could also be used to renew a lapsed a lapsed nomination as well. Okay, say the person forgot to remove the old relationship. Okay, yep, I've explained that. So if it's on there but there's no substance to it, I don't think it'll help. Can a trustee demand a stat dec before paying out? Well, asking ain't getting. You can demand it, may not be given, and if it is given, really, I think if it's given after the date of death, it starts to become a little questionable as to whether the substance of the stat dec is in fact there. But I don't think there's any problem in, there's no legal impediment to preparing the stat dec at that time. And I think the whole idea of the stat dec is to give some evidence where the other member of court, or the other spouse is not around to give evidence, so the surviving one gives the evidence, and whether it's given before or after the death, I don't think it matters, but it would obviously be more helpful and more persuasive if it was done before death rather than after. I think that brings us up to date with the questions. So I'll just continue on with the slides here. Okay, so we're talking about 617A, just apply what does. So the BDBN must be in writing, signed and dated by the member in the presence of two witnesses. Over 18 and neither of whom is otherwise mentioned in the BDBN, and containing a declaration signed and dated by the witnesses stating the notice was signed by the member in their presence. Okay, binding death benefits nominations gone wrong. What can go wrong? Lots can go wrong. The self-managed super fund trustee should be reviewed before a BDBN is made. Why? Why look at the trustee? Why do we have to look at the Constitution, which I'll talk about later where we're talking about corporate trustees? The fact is that the deed, the trust deed, is the agreement between the trustee and the members as to how the trust will operate. These are the rules. I'm signing up for these rules. I'm becoming a member of a trust with these rules. I have to follow these rules. The trust deed may need to be updated from time to time to reflect changes in the law. So bearing that in mind, the trust deed can in fact have provisions which even impact upon the constitution of a corporate trustee. So that's why both have to be looked at. But common mistakes include, as I've got in the overhead slide, the content of the BDN that the client wants to make is not supported by the trust deed. For example, the deed may not allow you to nominate that dependent. Another example is the form provided by the client is different from the form required by the SMSF trust deed. You're not using the right form. Another one would be, for example, the terms of the trust deed may be ineffective, for example, because the trustee doesn't require the trustee to act in terms of the binding death benefit nomination. So it says, yes, you can have one, but then it doesn't require the trustee to act in terms of it, or it doesn't explain what's to happen if, say, for example, numerous persons are nominated, but one of them doesn't qualify to receive a benefit. Is the whole of the nomination then ineffective? We don't know. So that's good. No more questions just at this point in time, so we'll move on. Don't make the simple hard, the old KISS principle. I think is very relevant in this area. Like the poor old Donovans in the Donovans case in 2009 in Queensland. The wording in the trust deed was this: a member may, not must, may make a binding death benefit nomination in the form required to satisfy the statutory requirements. After some days of machinations, the court finally concluded that this meant that the binding death benefit nomination had to be in the form described in Regulation 6.17a. So this is an example of where the wording of the deed can sometimes be ambiguous and cause strife. It's very easy to slip up in these areas. What are the advantages of binding death benefit nominations? Well, the idea behind them is that they are meant to provide certainty as to how a member's death benefit will be distributed, as without it the trustee will be required to allocate the benefit among the member's dependents and the legal personal representative if allowed by the trust deed. Now I've got another question here. If the donee under the enduring power of attorney reinstates the binding death benefit nomination, does it need to keep the same nominated person that was in place, or can a new person be noted? This is from Bob Curry. The answer to that is the attorney under the enduring power of attorney can do what they want, subject to this issue of preferring their own interest as opposed to interests that they may have as, for example, an administrator of an estate, which is the case that I'll be referring to. The court said, it was a Queensland court, and the court said, look, you're administrator of the estate, and the administrator has to call in and collect the assets of the estate. You're saying that you've got an enduring power of attorney which you use to nominate yourself. That's in breach of your obligations under Section 52, I think it was, of the Queensland Succession Act, so we're not going to allow it. So you have to be very careful when you're taking on the drafting of binding death benefit nominations under an enduring power of attorney. Okay, so moving on. Advantages of binding death benefit nominations continued. Who is the trustee to be after the member's death? The advantage is, so-called advantage, the member doesn't have to worry about this if you have a binding death benefit nomination. You also don't have to worry about how the trustee, even if you do know who they might be, how they are going to exercise their discretion. You don't have to worry about that. In any event, these two bullet points are the theory. The fact is, we'll see some cases, the reality is quite different. One of the benefits of using BDBNs is in specie distributions. Many are unaware that a binding death benefit nomination can be used to direct that a particular asset be distributed in specie, as it is, to a named beneficiary. This is particularly popular, for example, where you've got business real property, which is in the super fund, but the recipient of that business real property is to inherit, say, for example, the family business under the will. So it's a great strategy. What you need to consider, of course, in relation to in-specie distributions is you may need to ensure that the SMSF trust deed allows for it, and then you have to think about what if the asset is sold before the death benefit nomination is acted upon. And there are other questions that need to be considered as well. You have to describe the asset carefully. You have to think about what if the asset changes in value over time and if the intended recipient predeceases the member. So again, more questions that need to be considered at the time the binding death benefit nomination is being drafted. So Keith Powell has asked a question: if a BDBN is made to each spouse and both spouses die together, does it go to the legal personal representative of each member? So under the laws of the Succession Act in New South Wales, and I think that's the case in all other states and territories, where people die in a tragic accident, a car crash or whatever it is. And say, for example, there's no, the coroners and doctors can't determine who died first, then it's taken the situation is taken to be that the older of the two has died a split second before the younger. So that would then be the determinative factor of this question. So each person's made a binding death benefit nomination to each other, then the older is taken to have died first, and then the nominations would be acted upon on that basis. So thank you, Keith, for that question. Okay, now, okay, here we go. So thwarting Family Provision Act applications, binding death benefit nomination can be used, other than in New South Wales, to dispose of assets outside the laws applying to wills and estates throughout Australia. New South Wales has notional estate provisions under the Succession Act, which provide that a person may be able to apply to have certain property designated as part of a deceased's notional estate. And the key parts of that, of the Succession Act, are where the relevant property transaction took effect within 3 years prior to the deceased's death. So you've got a clawback period of 3 years, and it was entered into to defeat or limit the provision being made to the applicant. So that's a issue of intent, and the applicant will have to show the intention of the deceased and when they made the transaction to defeat or limit provision being made to the applicant. So you have to prove A or B, A and B I should say, or if the transaction took effect within 1 year of the deceased's death, where the deceased was under a moral obligation to make provision for the applicant, and that obligation was stronger than the moral obligation to enter into the transaction, then the transaction can be set aside. So it's not easy to get into the in between the years of people, particularly when they are deceased, and the notional estate provisions of the NSW Succession Act are notoriously difficult to rely on and to prove. Restricting the class of dependents. If your client is concerned that a particular superannuation law dependent is or will make determined efforts to challenge your client's arrangements, then you can consider amending the trust deed to restrict the class of persons who are taken to be dependents. One way to do this, for example, is to, you can say, restrict the definition of dependent in the trust deed by stating that only legal spouses qualify, or the spouse must be living with the member at the time of the member's death to qualify, or child only includes a natural child, or you might say that a financial dependent only extends to the member's spouse and children. Another way you might do this would be, for example, to simply name the potential beneficiaries and restrict the right to amend the naming clause and the clause restricting that right. So you've got to be careful when you're restricting rights in trust deeds because clever drafters will see if they can get around it. Of course, there are disadvantages to a binding death benefit nomination. Not properly drawn, you might nominate to my wife, but the member doesn't have a wife, only a de facto, and they were never married and never became married. What does that mean? The formal requirements under the trust deed may not be met. There can be changes in tax laws. Members' circumstances can change. They can be separated, divorced. The beneficiary can cease to be a dependent or can die, of course. A will is reviewed. This is very common. The will is reviewed, but the BDBN is not. Or the BDBN is reviewed, but the will is not. Common mistakes can be made. This is a classic one. We get these self-serve documents that people prepare, and they receive them, holus bolus, and the member simply signs them, thinking that they're doing the right thing, signs all the documents that have been provided by this provider they've been in touch with, and they sign the binding death benefit nomination and a non-binding death benefit nomination, not appreciating the difference, but they simply sign them both because they are in the suite of documents provided. I've had documents being signed by SMSF providers, and the client thinks they've got a self-managed super fund, and there's no money in the account. No assets are being transferred to it. Well, the fact is that a self-managed super fund is simply a type of trust deed. It's governed by the common law dealing with trusts. And the Superannuation Industry Supervision Act simply says if you've got a trust deed which complies with this Act, then you can get tax benefits, which are referred to in the 1936 and 1997 Tax Act. So, one needs to be careful. The law of trusts applies. If there's no money in the account, this client had signed not only the solutions but also the trust deed, as I said, thinking that he had a self-managed super fund, then instructed me to put some real property into it, which I was happy to do. I said once the superannuation fund came into existence. So another mistake is where, just getting the slide here, yes, the member states 50% to my son and 50% to my daughter, but the daughter predeceases, meaning the BDBN will either fail altogether or only dispose of 50% of the benefit. It's another classic. I've got a question from Ashley Tyndall. Issues with members completing a BDBN says that 100% of the estate instead of LPR. I'm not quite sure what that question means, Ashley. It doesn't have to go to the LPR. It go to 100% to estate instead of the LPR. I see. Well, that would be void. There's a question on that where a solicitor said it. We'll get to that if we have time. The solicitor said he gave 100% to his the trustee of his estate, assuming that the executor and the trustee were one and the same person, which they were. The problem is that the executor it doesn't become trustee, as the court determined, until the executor has finished their duties in executing the wishes of the deceased. Then, once he's done or she has done that, then assuming the will provides for it, the executor becomes a trustee. So if you're saying 100% to, quote, to the estate, close quotes, the SIS Act clearly says it's got to be to the legal personal representative. And that's the way it's got to be. You've got to use those three words, my legal personal representative. You can name the person, but there's a danger if you name the person, John Smith or my wife Mary Smith. If you name the person, and if that person is also the legal personal representative, do you mean the person in their own right, or do you mean the person in their capacity as legal personal representative of your estate? So all these things where people are very casual about these documents and form filling and it's really easy. If you don't actually know what you're doing, it can cause all sorts of problems. Another question from Lindsay. So a BDBN must be to an actual person rather than their potential capacity. Well, no, you can say the legal personal representative of my estate, and assuming that capacity is a legal person and you haven't appointed the public trustee or whatever, it's better to actually say the legal personal, or John Smith being in his capacity as legal personal representative of my estate, where you've got both. You've named the person and you've explained that it's not to them as an individual, but to them in their capacity as legal personal representative, to put it beyond all doubt. Okay, so here it is, so what we're just talking about. To John Smith, but John Smith is both the executor of the will and also dependent. Does the estate benefit, or is it a gift to John personally? The long and short of it is that the courts are likely to say this is void for uncertainty. And another example, Fred Nerk, but Fred is not a dependent, then Fred's not going to get it. Other mistakes, to my spouse, but on death the member is separated, but not divorced from the legal spouse, and also has a de facto spouse. Again, the binding death benefit nomination is probably void for uncertainty there. Binding death benefit nomination is signed and witnessed, but undated. If it is undated, it's arguably not intended to operate. That's why we have dates. I want this to operate from the date that is applied to this document. What if there is a prior binding death benefit nomination which is signed and witnessed and dated? In that case, that would almost certainly become the operative binding death benefit nomination. The binding death benefit nomination is signed but not properly witnessed. That'll be void because it doesn't comply. Or the original is lost. Does this evidence an intention to revoke it? Depends on the circumstances. Or a later will is inconsistent with the binding death benefit nomination. Does that revoke the nomination? Depends on the facts. It could, maybe it does, maybe it doesn't. The binding death benefit nomination meets the requirements of the trust deed, but not a new trust deed which has no saving provisions. So, and I've had this, clients come in, they speak to you in a vacuum or want to speak to you in a vacuum, you ask some probing questions, you find the trust deed has been amended 3 times and they can only put their hands on 2 of the preceding documents. So as advisors, we really have to ask for everything. Like a barrister, when they deal with a case, they want everything. Let them make the decision as to what's relevant and what's not. It's not up to us to leave it to our clients to determine what's relevant and what isn't relevant to give to their advisor. And that's we can't be too blinkered when giving our advice. More mistakes, Munro and Munro. This is the case I was referring to. Barry Munro was a solicitor. His second wife, he was married to his second wife. He had 2 daughters from his previous marriage, and this is a classic setup where we have problems. And he and his wife, Barry and Susie, were the co-trustees. He died, and his second wife appointed her own daughter to become co-trustee of the self-managed super fund with Susie in 2012. Before he died, he had a binding death benefit nomination to the trustee of my deceased estate. And as we mentioned, that doesn't comply with the requirements of the Act, and Susie and her daughter argued that an executor only becomes trustee after the estate has been administered, and the Regulation 622 requires a payment to be made to a dependent or the legal personal representative, which is defined to be the executor of the will, relevantly for this case. So the conclusion was that the BDBN was held not to be binding at all. Susie and her daughter applied the proceeds to Susie and not the deceased's daughters. And of course, they would have benefited under the will had the solicitor been a little bit more careful. Now, John Hyolis has asked a question. What happens if an individual leaves their super 100% to the estate or LPR, or whichever is allowed within that specific super fund, but they don't have a will in place and they pass away? Okay, so the question there is, if you don't have a will, then the laws of intestacy will apply. So that's okay, and the laws of intestacy are determined by each state or territory act. Another question from John, is there an issue here as a super is being directed to the estate but there is no valid will in place? So if there's no valid will, that's why we have the fallback position of the intestacy provisions to deal with the fact that 40% of Australians don't have a will. So, you know, the intestacy provisions are alive and well and operate very frequently, are called upon very frequently. And as you may know, where there is no will, you don't become an executor. The court appoints an administrator of the estate. Katz and Gosman is a classic case of what can go wrong. 2005, New South Wales. Husband and wife were co-trustees of their self-managed super fund. Wife dies, husband appoints their daughter as co-trustee. He creates a non-binding death benefit nomination. so apologies for that typo. It's a non-binding death benefit nomination, leaving his benefits to his daughter and to his son. He then dies, and the daughter appoints her own husband as co-trustee, and they refuse to follow the late father's non-binding death benefit. And there's nothing the son could do about it. So, this is the slide, ladies and gentlemen, the take-home slide of this whole presentation. Non-corporate trustees cause problems. That's the bottom line. Your clients want to take a shortcut and don't want to come up with $1,000 or so, you know, to save money, and it's all too expensive. They're going to have problems. There's a good chance they'll have problems. Non-corporate trustees cause problems, and where beneficiaries are not in control of the self-managed super fund, difficulties not only can arise, but do arise. So that's the bottom line of this presentation. Now, we're going to talk about the alternatives and who should have control after death. And Worcester and Morris is an example of who should not have control. Mr. Morris had 2 adult daughters from a prior marriage, and Mrs. Morris was his second wife. They were both co-trustees, okay? There's no corporate trustee, co-trustees, husband and wife, co-trustees. He made a binding death benefit nomination in favour of his 2 daughters. He dies. His second wife, Mrs. Morris, appoints herself as sole director and shareholder of the new corporate trustee and decides that the binding death benefit nomination is not valid and pays herself over $900,000. Thanks for coming. What do you think the ground was in relation to the binding death benefit nomination not being valid? Okay, she said it was never ever served on the trustee as required by the trust deed. Well, as it turned out, the binding death benefit nomination was attached to the wife's affidavit. How could she possibly attach it if it hadn't been served on her? This is an example where lawyers, in my humble opinion, can sometimes get so engrossed in their clients' affairs that they can lose focus themselves. But irrespective of that issue, the argument is clearly so flimsy, and it's very comforting to be aware that the court saw through the whole argument. But the bottom line is, where you have these loose ends, we're going to get massive legal fees, lost time, stress being suffered by all involved. So, planning for control of a self-managed super fund with a corporate trustee. SMSF ruling 2010/2 comes to the rescue. This describes the operation of Section 17A. Section 17A provides that an LPR, now an LPR can be an executor of the member's estate or the member's attorney under any enduring power of attorney. Either of those people can be a director of the corporate trustee. That's all very fine, but how do you get there? How do you appoint them? What do you need to do? And generally, you only want them to be there when you're deceased, and of course then by that stage it's too late to appoint them. So some care needs to be taken when people want binding death benefit nominations. It opens up a whole area of further consideration, and if you just sign these forms in a vacuum, potentially there can be problems, as we have seen from some of these cases. So the most popular method is the use of successor directors in the trust deed and the constitution of the company. Both need to be read, both need to be digested. The successor directors can be named in the documents. A, if not A, unable or unwilling; B, if not B, unable or unwilling, then C. For illness and infirmity, the use of alternative directors. You can appoint an alternative if the trust deed provides for it and the constitution of the company provides for it. Alternative directors are a valid way of doing it as well. But Section 118 of the SIS Act says that you've got to get the directors, pardon me, written consent that they are willing to act as director before they are appointed. So that's a little trap for young players, Section 118 of the SIS Act. Okay, I've got a question here. What should have been in place in the Munro case? So in the Munro case, of course, Barry said, had his, the wording in his binding death benefit nomination was to the trustee of my deceased estate. He should have said to my two daughters, his names were Vanessa and Elkie Munro, in their capacity as legal personal representatives of my estate. If he'd done that, there wouldn't have been a problem. So thanks for that question. Okay, we're getting a lot of questions here. Is acknowledgement of receipt or acceptance of the BDN required? Well, it is. But in the case in point, the fact is that she obviously had it because it was next to her affidavit. Could you please confirm the answer to John May's question 5 questions back? So a binding death benefit nomination must be to a natural person rather than their capacity. I think I've mentioned that, but it needs to be, the Act says that it needs to be either to a dependent, which is a natural person, or the legal, it actually says, or the legal personal representative. But the cases have indicated that, for example, if you nominate the person without nominating their capacity, and that person is also a dependent, then you've got potential uncertainty problems, and the nomination can be void for uncertainty. So, as I've mentioned, you need to, the best way is to nominate the person and their capacity. If they're to be legal personal representative, or if they are a legal personal representative, say to John Smith, in his capacity as legal personal representative. What is the constitution is a question from Max Zeng. What if the constitution of the trustee company is not in line with the trustee? Then you've got a problem. The trustee may well prevail. But the inconsistency needs to be addressed. And rather than just relying on somebody else to figure out after the problem arises, assuming the trustee does prevail in its terms, assuming it does prevail, I'm not saying that it necessarily would prevail, but if it's silent on the point, it may not have any comment on what the constitution of the trustee company says. But if it actually touches on it, then it will prevail, so that needs to be addressed. Okay, we better move on. We've only got 10 minutes or so, and we've still got a fair way to go. Okay, so next question. Next slide. We need to follow the steps in the trust deed and the company constitution in relation to the appointment of individuals as directors of the corporate trustee, and if there are none, then amend them to ensure that there are. What if the proposed appointee predeceases the member or themselves becomes infirm? Good question, and that needs to be addressed. It needs to be addressed at the time. Okay, so if the LPR is appointed while the member is still alive, then this may require the member to cease to be a director unless the LPR is appointed as an alternative director. So care needs to be taken in the wording of the trustee and the company constitution, and the ramifications of making an appointment need to be taken into account. Okay, planning for controllers. We're talking about the appointment and removal must be in accordance with the Trust Deed, the CIS Act, and other relevant legislation, as well as the Constitution, of course. Now, it's an interesting issue in relation to multiple attorneys. You can, of course, appoint one or more people as an attorney, and you can therefore appoint one or more people as your director if they're all attorneys. Multiple members can execute their separate enduring powers of attorney in favour of the same LPR. So two directors can nominate the same person to be their LPR under an enduring power of attorney. And where they are both deceased, the trustee company will then only have one director. But you must ensure that the Constitution allows for only one director. So all these things have follow-on effects and flow-through effects which need to be thought about. Also, a member can execute an enduring power of attorney in favour of an existing member who is already a director in their own right. So you see there are a number of variables which can apply. And here are some problems which need to be addressed. What about if there's a deadlock, pardon me, with the voting of the corporate trustee? What does the Self-Managed Super Fund and the corporate trustee constitution say about voting deadlocks? Does the chairman have a casting vote? Is there a provision for the director with the most shares to have a casting vote? Pardon me. What matters fall to the directors to resolve and what matters fall to the shareholders to resolve? And do members with the greater fund balance automatically have the majority of shares? Does the SMSF trustee provide for a majority of members to hire and fire the trustee? That could be disastrous. You've got your trustee, you've got the shareholders of the trustee, you've got the directors of the trustee, only to find that the members of the Self-Managed Super Fund can sack the trustee. So all these issues need to be thought about at the setup phase so that your best intentions are not thwarted. What's the extent of a power under a power of attorney? We touched on this in this Superannuation Complaints Tribunal Determination DO7-08/030. Basically, the tribunal accepted that the power of attorney under an enduring power of attorney did extend to completing a binding death benefit nomination, but in that case, as I mentioned, the legal personal representative wasn't a dependent. They nominated themselves, and as legal, and they used the words legal personal representative, and appealed the trustee's decision because they said, it should be paid to me personally, not as LPR of the deceased estate. But the tribunal said, well, you're not a dependent, so it could only take effect in your capacity as legal personal representative of the estate. And rather than make that decision, the tribunal set aside the trustee's decision, held that the nomination was void, and distributed the whole estate to the members' estate, of which the son and daughter were the only beneficiaries, so the LPR missed out entirely, which is an entirely appropriate decision in my opinion. Okay, so we'll move on to now 6, avoiding results of recent cases. This is a classic case. Mr. and Mrs. Conti were the sole trustees and members. Mrs. Conti made a will and died. Mr. Conti continued as sole trustee. Mrs. Conti's will stated, my superannuation entitlements are to be given my 2 children. But Mr. Conti ignored that, got some legal advice, got some tax advice, was told, no, you don't have to worry about that. And he didn't, and he paid the whole amount to himself. And he then got a corporate trustee, which is by the by. The court said he was entitled to ignore the direction in the will, and the mere fact, note the mere fact, that he did so could not in and of itself be evidence of a lack of bona fides. And here are the lessons from Conti. Without an appropriate mechanism, an executor of a will is not automatically appointed as trustee of the fund or as a director of the corporate trustee, and a will does not deal with superannuation interests. So you can't say in your will, oh, I want my super funds to go to my kids. It's not going to happen. Third issue, the persons in control of a self-managed super fund where the member dies will most likely be the persons deciding on the allocation, and that's the issue. That needs to be borne in mind when preparing the binding death benefit nominations. Macintosh is another one. Only got a couple of minutes, so I'll be quick. This is just last year in Queensland. Mr. and Mrs. Macintosh divorced in 1979. Their son had no will, no spouse and no children. He died many years later in 2013. He'd been living with his mother for many years, and under the relevant intestacy laws, his estate was to go to his parents equally. But Mrs. Macintosh, she applied for letters and was granted letters of administration of his intestate estate, and his super fund was worth $450,000. She then applied in her own right to the super fund trustee to have the benefits paid to her because she was a superannuation law dependent by reason of interdependency, which she was. She was a dependent by reason of her interdependency, and the trustee agreed, but of course Mr. McIntosh had a problem with that, and it went to court. And as I said earlier on in this presentation, the Queensland Succession Act, Section 52 says that, look, gee, you know, you're a personal representative of a deceased estate. You've got a duty to collect the assets, and when you made the application to the super fund trustee, you're preferring your own interests and therefore in breach of your fiduciary duty. And so that's not going to happen. And she had to pay the proceeds she received into the estate, which was then shared 50-50 between her and Mr. McIntosh. And we could see that the situation would have been totally different if the son had had a will, which appointed the mother as executor, making it very clear, and that he also had prepared a binding death benefit nomination in her favour. So, well, folks, that brings an end to the presentation. Michael, I'll hand it over to you if there are no more questions. I don't think there are any more questions at this point.
Thank you for that, Leigh, and thank you for everyone for attending today's session. Most appreciated. There were some fantastic questions that came through. Leigh, thank you very much for a very, very informative session. Guys, just to let you know, as you're leaving this particular session, there is a feedback form that pops open. It would be great if you could take the time to fill that in. Great feedback for the FPA and also great feedback for Leigh as well. Just keep an eye to see if there's any other questions coming through, but there's lots of thank yous, so thanks for doing that, guys. Thanks again, everyone. We look forward to seeing you in another session real soon. Until then, enjoy the rest of the week.